Sports games have long been a substantial part of the gaming medium. Some, like this early edition of Avalon Hill's Baseball Strategy, or 3M's Challenge Golf at Pebble Beach, do not use real-world athletes in the game. Others do. Of the ones that do use real-world athletes, many go further and also incorporate the real-world performances of these athletes into the games. Tabletop games incorporating real-world athletes and their performances date back to a game called National Pastime, a baseball game patented by Clifford Van Beek in 1925 and published by Major Games in 1930. Electronic games incorporating real-world players and performances date back at least to Strategic Simulation Incorporated's Computer Baseball and Avalon Hill's Major League Baseball, both published in 1981. The use of real-world athletes is clearly a desirable feature in tabletop and computer sports games, especially for any game that aspires to be a marketable simulation of a sport. Challenge Golf at Pebble Beach uses 4 fictional pro golfers named Old Smoothie, Boomer, Ironsides, and The Blade, an approach that leaves a lot to be desired. So why didn't the designer use real golf pros? Inserting a real-world athlete into a game raises an important legal question. Does the law require you to get the athlete's permission, which you would probably have to pay for? Answering this question requires some consideration of both federal and state law, but the focus today will be on state law, specifically what is usually called the right of publicity or sometimes the right of privacy. I'll set aside for now why two seemingly opposite terms are used for the same or almost the same legal doctrines. Today, we will be revisiting the first published judicial decision to address this question about the use of real-world athletes in games, a case decided in 1967 by the New Jersey Superior Court about a very rare game called Pro-Am Golf. The case was Palmer versus Schonhorn Enterprises, Incorporated. My guests are Professor Gordon Hylton of Marquette Law School, Jonathan Jennings of the law firm Pattishall, McAuliffe, Newbury, Hilliard, and Geraldson, and finally, Lester Munson of ESPN and ESPN.com. That's today on Games Are Not Coffee Mugs. When it comes to the right of publicity, the basic rules for living individuals, and sometimes even deceased individuals, are as follows. Permission is ordinarily required to use someone's name or likeness in an advertisement or for purposes of trade. A use for purposes of trade would include using someone's face as the logo for a product, such as a bag of flour, or using someone's name or likeness on merchandise, like a t-shirt or a coffee mug. This Arnold Palmer mug, for example, says that it was licensed by Arnold Palmer Enterprises, Incorporated on the bottom of the mug. That was the right move by the mug manufacturer. On the other hand, permission is ordinarily not required to use someone's name or likeness in a newspaper article, a book, a television show, or a film, what's termed non-commercial speech by the courts, even when it's sold for profit. The Chicago Tribune, for example, wouldn't ask permission to mention Arnold Palmer or other athletes in an article in the sports section, and they don't need to. But what about a sports game? Where do games fall in the right of publicity spectrum? For purposes of the right of publicity, are these games more like newspaper articles and television shows? Or, despite the title of this webcast, are they more like coffee mugs? We have to go to the case law for an answer. The answer to our question starts with 3 judicial decisions, one from 1967, one from 1970, and one from 1973. The first decision, Palmer versus Schonhorn Enterprises, involved this game, Pro-Am Golf, a game designed by Erwin Schonhorn and apparently the only game ever published by Schonhorn Enterprises. Players of the game can choose from among 23 golfers to play. Each golfer has a card that provides the results for each stroke. 20 of these cards are for professional golfers, including Arnold Palmer, Gary Player, Doug Sanders, and Jack Nicklaus. 3 of the cards are for amateur golf enthusiasts, including Bob Hope, Bing Crosby, and Jackie Gleason. Palmer, Player, Sanders, and Nicklaus sued because they did not authorize their appearance in the game, and they prevailed. In explaining the legal rule involved, the court said, quote, "The basic and underlying theory is that a person has the right to enjoy the fruits of his own industry free from unjustified interference. It is unfair that one should be permitted to commercialize or exploit or capitalize upon another's name, reputation, or accomplishments merely because the owner's accomplishments have been highly publicized." End quote. In 1970, the United States District Court for the District of Minnesota confronted a similar issue in Ulander versus Henriksen, a case about these two baseball games, Nagamco's Major League Baseball and Big League Manager Baseball. Unlike Pro-Am golf, these games included hundreds of athletes, 500 to 700 Major League players, said the court. The court quoted Palmer at length and reached a similar conclusion. The court held that the defendants violated the plaintiff's rights in their names and statistics by appropriating them for commercial use. In 1973, in Rosemont Enterprises versus Urban Systems, a New York State court resolved the third case, this time about the Howard Hughes game. Unlike the earlier two games, this game is not a statistics-based sports simulation, but it does include extensive biographical material about Howard Hughes. The court said it was not trying to formulate a hard and fast rule, but it cited Palmer and Ulander and reached essentially the same conclusion. Unlike the other two cases, this one was appealed and affirmed. Although two of these three decisions would not be binding in any later cases, and even the third case would only be binding within New York, these three cases likely played an important role in establishing the rule for the right of publicity's application to games, establishing a rule that permission is required to put someone in a game. For example, in listing the sorts of uses of a person's name or likeness that require permission, the Restatement Third of Unfair Competition lists multiple examples, such as posters, buttons, trading cards, photographs, T-shirts, busts, and lastly, games, citing Palmer, Ulander, and Rosemont. After the original trilogy of cases, published judicial decisions involving the right of publicity in games largely disappeared, until recently. In recent years, the issue has received extensive attention in the courts, including a fantasy baseball case in the Eighth Circuit and video game cases in the Third Circuit and the Ninth Circuit. While the Third and Ninth Circuit cases involving Electronic Arts NCAA football and basketball games are headed towards settlement, there is still an appeal pending in the Ninth Circuit involving retired NFL players in Electronic Arts Madden NFL games. The issue is still live, but it starts with Pro-Am golf and the Palmer decision. Before turning to the roundtable discussion of these issues, let's take a closer look at Pro-Am golf. With me right now is Professor Gordon Hylton of Marquette Law School. We've played through 3 holes of the Pro-Am golf game. We're now on the 4th hole, and this is the one that we'll use to demonstrate the game to you. The first thing that we need to do is put down this color form-like flag on the acetate sheet that goes over the hole. And according to the rules, we can put that anywhere on the green that we choose. We next need to put down this piece to designate where we will tee off from on the 4th hole. Now at this point, I'm playing Arnold Palmer and Professor Hylton is playing Sam Snead. Why did you choose Sam Snead?
Sam Snead was the pro in White Sulphur Springs, West Virginia, where I was living when I started at the 1st grade. So he's a local hero.
I chose Palmer for the obvious reason that he's the first named plaintiff in the lawsuit that we're discussing today. In another situation, I might very well choose one of the amateur players, probably Bob Hope. All right, so we each have 2 markers for our balls. I have orange, you have yellow. Yes. Because you won the last hole with 5 strokes to my 7, you'll go first on this one. So what we do is we take the yard ruler, and as a player, you can put it down in any direction that you choose with the 0 point starting at the tee, and then you roll the dice to see how far your ball goes on the yardage ruler.
And I'll be hitting with my driver.
Okay.
And I roll a 2, which actually Sam Snead hits the drive of his life and drives the ball 330 yards without any variance.
All right, an excellent first stroke for Sam Snead. All right, I'm content not to move the yardage ruler. I'll leave it right there. I will be hitting with the driver as well. With a 9, Palmer hits it 280 yards. All right, trailing not too far behind you. And so far, this hole's going much better for Palmer than the last one where I hit it right into the water. All right, I'm further away, so I will take the next stroke. Oh, I should choose my club before I put down the yardage ruler. We decided that would make it more challenging. I will choose the 4-iron. All right, 4-iron. for Palmer's second stroke. 6. That is 190 yards, hook 2. So,
that's on the green.
using my second marker, we go 190, but because it hooks, we need to see how far it goes. So, using the hook template, matching it up to where I hit the ball from, and I said it was hook, did I say 2 or 1?
You said 2.
Hook 2, okay. So now I am in the trees. Wow. But not the best outcome.
But close to the green.
All right.
All right.
Your turn.
I am going to use the 8-iron in hope of putting this right in front of the pin. All right. And I rolled an 8 with the 8-iron, so it comes out 130 yards.
That would put you right on the green.
Yes, with no slice and no hook.
No slice, no hook. All right.
So I'm just onto the green.
All right, the rule for landing in the trees is that I now have to make an extra roll of the dice. If I roll an even number, I'll be allowed to choose whatever club I wish. If I roll an odd number, I may only take a wedge shot. All right, so I rolled an even number, 6, and that means I get to choose a club. Now, it seems to me that I might want to take a wedge shot anyway, given how close I am to the green. So I'm going to use I'll use the wedge 3. All right, wedge 3 shot. With a roll of 4. A wedge 3 roll of 4 means 55 yards, and that's not good for me. That sends me out here. All right. Now, because you're on the green, we will now use the putting target on the yardage ruler. The center of the bullseye goes on the hole, and then we determine what area your ball is in, and it looks like you're in area 5.
All right.
So that is a separate column on the putting chart, area 5. And this will be your third stroke?
Yes,
Third stroke.
but not looking very good here. I have to roll a 2 or a 12 to get it into the, and I rolled a 10, so that puts me into area 2. So
All right.
I'm closer, but still not.
Now at this point, there's no need to move the ball or the ball marker. We can simply take note of the fact that you're in area 2 and the next roll will be on the area 2 chart. Now, I'm outside the green, although I'm within the putting chart, but I'll be shooting from the rough. All right, so shooting from the rough with a wedge shot. Two. Well, I would need to designate which wedge it was. Presumably I would have picked the...
Probably 4.
I should probably be penalized and it should be sent 80 yards,
No.
but presumably I would have picked the wedge 4.
Yes.
And I would go 20, which would put me probably within area 1.
Right on the
All
pin.
right, let's double check that. Yeah, I would be in area 1.
Nice shot.
All right, so you're in area 2
Yeah,
to
so-
sink your putt.
So this is my 4th shot, I believe.
4th one.
I roll an 8, which only brings me to area 1. Wait, area 2. 8. Yes, I missed the putt.
You missed it. So you're in
So
area 1 now?
Now I'm in area 1.
All right, and that was your 4th. All right, this will be my 5th. I am in area 1, putting with a roll of 8 on the putting chart in area 1. I am in. All right.
All right, very good.
5 strokes, which is 1 over par on this hole.
So this, I think, is now my 5th shot, my 3rd putt.
This would be your 5th, correct?
And the 7, which puts me in.
All right, so we were tied on this hole. For the 4 holes we've played, that puts me at 23 strokes as Arnold Palmer, and that puts you at 19 strokes for Sam Snead. So you are in the lead.
But par is 17, I think. So we're both not having our best day.
We are not having our best day. All right, well, this gives you an idea of how the game works. Next up will be our roundtable discussion on the legal issues involved in this particular case. Still with me is Professor Gordon Hylton of Marquette Law School. Professor Hylton is a graduate of the University of Virginia Law School and holds a PhD in the history of American civilization from Harvard University. In addition to teaching sports law and other courses, Professor Hylton chaired the committee that created Marquette's sports law program and is a former director of the National Sports Law Institute. He is the author of numerous books and articles, including articles about athletes and the right of publicity. Now joining me is Jonathan Jennings of Pattishall, McAuliffe. Mr. Jennings is a graduate of Northwestern University Law School and is a partner at Pattishall, one of the top IP law firms in Chicago. He specializes in trademarks, copyright, trade secrets, the right of publicity, contract law, unfair competition, and false advertising law. He also helped to draft the Illinois Right of Publicity Act. He's also an adjunct professor here at John Marshall. Lastly, joining me today is Lester Munson of ESPN and ESPN.com. Mr. Munson is a graduate of the University of Chicago Law School and has covered sports and sports law issues for over 2 decades, now with ESPN and previously with Sports Illustrated. Over the past 3 weeks, he has been in California covering the O'Bannon versus the NCAA trial in the United States District Court for the Northern District of California. He is also an adjunct professor at Northwestern University's Medill School of Journalism. Okay, let's start with a very broad question. I can accept that there are definitely some games that have nothing to do with the celebrity or famous person involved. This example is one of my favorites. It's the No Respect Rodney Dangerfield game. The game has absolutely nothing to do with Rodney Dangerfield beyond a reference in the instructions to choosing the first player to go when playing the game. And the first player to go is the one that has the least respect in the group. Beyond that, there's no connection between Dangerfield and this game. Presumably, this is a licensed use of his name and likeness, but it doesn't have anything to do with him. Now, I recognize that this particular game is not a familiar one. It's an abstract strategy game, but not well known. But for comparison purposes, imagine a game like this one, Othello, a more well-known game. Suppose it was renamed the Orson Welles game. Orson Welles has no connection to the game beyond the fact that he was involved in directing and starring in a film adaptation of the other Othello, but he would have no connection to the game. This Pro-Am golf game, on the other hand, clearly does have a connection to the golf players, the professional golf players, and even the 3 amateur golf players involved. And yet the court found that this game was a violation of the players' rights of privacy under New Jersey law. What's going on in a case like this when you have a game that's clearly about the players, unlike the Rodney Dangerfield game or my hypothetical Orson Welles game? What's going on in a case like this where the defendants come out on the losing side? I'll start with you, Professor Hylton.
Well, of course, the case was decided as a right of publicity case, but I think in light of what's happened since the case, it's really, we would really call it a right of publicity case.
It was framed as a right of privacy case.
I'm sorry, yeah, framed as a right of privacy case. It is a mystery to me of why this court in New Jersey in the mid-1960s felt that it was necessary to recognize that these professional golfers had a right to their names and statistics, to the extent that those facts, which at least many people would have assumed at that time were in the public domain, could only be used for purposes of making a game with a consent or with a license from the players. So I think this is really a landmark case that signified the willingness of American courts to recognize the facts about one's existence as a form of property.
Now, the court was willing to acknowledge that the publication of biographical data of figures like famous golfers is protected when it's in a more traditional form of media, if it's in a newspaper or in a book. The game, however, was treated differently. why the distinction between the traditional form of expression and the game in this case?
Well, this is seen as an item of merchandise. At the time, it wasn't seen as something where people are expressing viewpoints. This is purely like a toy that might be branded, a doll that might be branded with Arnold Palmer's name on it, and so an action figure, something like that. And I think that's what the court was looking at. And in reality, the court was not focusing at all on First Amendment or freedom of expression ideas. And I think that is in part due to the fact that it appeared that the defendant didn't raise those issues. So a court will only address issues, for the most part, that come before it. And so in part, I think this case is a bit of a product of the times, in the sense of have a different perspective on the way games can play a role in our society, and I also think that it's part of the fact that the issues were not really framed like they are today in some of the games cases.
Now, one feature of the game that doesn't come out from the opinion, the court was not attentive to this, is that the yardage sheets for each of the professional players is supposed to be calibrated in some way to that player's real-world performance. So as you roll the dice and determine where the ball goes, the result is supposed to be in some way based on how each golfer performs in the real world. Now, I don't know how the statistics were calculated, but that suggests going beyond just sticking names on dolls or names on merchandise. In talking earlier, you expressed some skepticism about being able to incorporate someone in a game without permission. But does the fact that these types of games, these sports games, are based in part on the player's statistics, does that change your view at all or affect your view of these types of cases?
As one who makes a living within the First Amendment on a daily basis, I think I have a bit of a bias here. I'm trying to preserve the First Amendment for us in the media. I don't want a new crowd coming in. But at the same time, I can see how a celebrity athlete, in this case, Palmer, Nicklaus, and Player, you couldn't have bigger names than they chose to put in the game. I can see how using their, let's say Arnold Palmer's average length of his drives, putting that in the game makes it specific enough to me that I would think Palmer has a right to decide whether or not he's going to be in that game. As I'm looking at this, and based on the current litigation, the more specific the game is to the player, the greater right the player has to control the use of name, image, and likeness.
Now, in some ways, these games can be a form of commentary on the players. To take another example, although we don't know the details of how the statistics were calculated in this game, we do know more about how they're calculated in the Stratomatic game. A journalist named Glenn Guzzo wrote at length in one of the chapters in this book about the efforts that the Stratomatic team would go to calculate the defensive ratings of each of the baseball players in the game. It involves a committee of people at Stratomatic getting together, going over not just statistics, but also reports from observers in the field and also the observations of the people who are actually at Stratomatic. And they sit there and they argue and negotiate and discuss whether each particular player's fielding rating should be a 1, 2, 3, 4, 5. And that's an interesting way, I think, to comment on the players. And the players, maybe not so much now, but at one time, Stratomatic was popular enough that players would pay attention to their ratings, to this commentary that you can find on them in the game. Now, again, I'm not sure how exactly the numbers came up here, but you talked about being very specific to the player, just pulling from the sports page the real statistics. Now in Stratomatic, the statistics are adapted in some way, and they may have been adapted in this game also. I'm not sure that good data was available on how Palmer would perform with every single club on this particular golf course. Presumably some sort of estimates had to be made. So to the extent that's the case, does that pull you in a more sympathetic direction as opposed to just dropping in the published batting averages, the published ERAs, and basing the game on those?
I think that in the Stratomatic case, and then in a more recent phenomenon, the fantasy baseball, The people who wrote the original fantasy baseball book, a couple of them were colleagues of mine at Sports Illustrated, they did a similar thing. And somehow the law, I think, has evolved so that fantasy baseball, the players have no protection. They cannot do anything about use of their names and their numbers. So the law is clearly moving in that direction. I would probably, myself, want to see it move in the other direction so that a ball player had the right to decide whether or not that material was going to go in the game and they could collect something for it. But I may be in a minority position
Well,
on that.
I certainly disagree, I mean, just as a matter of my own view of this. And it seems to me, looking back at this case now, almost 50 years later, that the court rather cavalierly decides, well, of course, if this were a biography of a golfer, that would be protected. But since this is not a biography, this is a game, well, then that's entirely different and a different rule applies. I think if anything of the last 50 years has taught us is that one has to be very careful about making these kinds of categorical distinctions. I mean, it's always been the case that Sports Illustrated could put Michael Jordan's picture on a weekly issue, whether or not he had done anything exceptional that week, if it was interested in selling extra copies. And I think with the internet, with new technologies, it's hard to know what the press is now with 1 billion blogs, right? That the line somehow between expressive works like novels or journalistic works like Sports Illustrated and games, I think, is a much more blurry one than the court here suggested. In fact, I just saw this game recently for the first time, and there's a remarkable amount of text. There are 23 profiles of the golfers, which could have been published in a little handbook of biographical profiles of modern golfers and sold, and then it would have all been predicted. And he could have put all this data for the charts in the book, and that could have been sold, and that would have been protected. The idea somehow that you can classify it as merchandise, even though, as Bill says, it contains all this information, much of it the result of at least original calculations. I guess I just don't see the justification for why we have to let Sports Illustrated, give Sports Illustrated a pass from the right of publicity, but the maker of this Pro-Am golf game doesn't get one. I just don't see it.
Well, that's one of the oddities of these types of rulings. If you, as you said, if you put all of this information into a book or a magazine, you're fine. The moment you add the ruler, the board, and a pair of dice, you suddenly have a problem. You've crossed a line and you've become a commercial good. And what you said a moment ago about the court's views of games at the time, I suspect is right, that at the time, games were likely to be viewed in a different way than they would be today. Although I think there's still some misunderstanding of the medium, especially when we're talking about board games. Most of these games are going to be very obscure to people even today. I think it's unlikely that courts at the time would have been familiar with even the games that were in existence that went beyond the Monopolies and the Clues and the Sorries, games like APBA baseball or the Stratomatic line of games that contained a lot of information. So a court seeing this is likely to view it in the way that you described. This is a toy. This is a fairly silly way for people to pass the time, and you've added these golf pros to the game in order to sell rulers and maps and dice and things like that.
Yeah, I think that's right. I think they would not have seen some information that was built in about propensity of Jack Nicklaus to hook the ball as being what's driving this. It's purely entertainment, and in the court's mind, the celebrities are added simply to drive sales, and it's not a and it's like I said before, it's just in connection with a celebrity's name used with a product, and that's a prototypical right of publicity case. Even at that time, even though it was in the mid-'60s, some famous scholars had weighed in before that and said there should be this right. There should be what would be called an appropriation right, where somebody uses your identity that should be protected when they use it in a commercial way. And this would have been seen as a commercial use.
Well, and you've written about one of the landmark cases that would have stood for that proposition. The Hylton case, which was about baseball cards. So if you put a player on a baseball card, that's merchandise. And I could see a court thinking this is analogous to baseball cards. But we see developing this merchandise category, and games are being put into that category. They're being treated as the baseball cards, the posters, the T-shirts, and of course the coffee mugs.
If I can interrupt, it does seem to be there's one thing that happened in that period. The actual New York statute, which was at issue in many of these cases, because New York was such an important market, was originally about prohibiting people from using other people's images in advertising without their permission.
Or on a product, not merchandising their name and likeness, but putting the face on the bag of flour.
Right, but it seems to me the baseball card is different than the bag of flour. Right, the pretty girl on the bag of flour is trying to get people to buy the flour. The baseball card isn't about trying to get people to buy the gum, I don't think, primarily. I mean, even in that era, I think people were collecting cards and the gum was second.
The court might have thought that, though. If you read Hylton closely, I think the court thinks the card is a gimmick to sell gum.
Absolutely, yeah. Right. So this confusion about what's really going on, it seems to me, sets in the 50s. That, as you say, courts have not quite grasped what's going on in these memorabilia cases or these game cases.
Well, and this is the first one to tackle the game question. The second one, which you've also written about at length, is the Ulander case involving the Nagomko game and Big League Manager. Now, one distinction between that game and this one is that it has so many more players, hundreds of players versus 23. At that point, each particular player is a much smaller driver of sales. How do you think that ought to affect the analysis here when you go from 23 to many hundreds? Same type of game, though.
You're going from an individual sport with Palmer and Nicklaus to baseball with a 25-man roster. So the scale is going to change. You would think that that should not make a big difference in the analysis, but obviously it did somehow. So
well, the court came out the same way.
So, in Ulander, but not in a later case.
Yeah. Right.
I think what you're alluding to is more, does it become almost like a face in the crowd exception in a ball game? So in other words, if you have so many players involved, is not one of them identified? So if it becomes diluted, part of the process of making a claim in right of publicity is the object or the game identifying someone, an individual, not a group, an individual. And the more individuals you have, the less it becomes clear that you're picking on one particular person. And I think that may be what you're alluding to, and the question is, should that have an impact?
Well, in these early cases, the courts are saying it's unfair for you, the game maker, to be cashing in on Arnold Palmer. Once you're one of hundreds, it's harder to say you're cashing in on a particular player. But Ulander comes out the same way. The court says this is a violation of the rights of publicity of the baseball players, despite each player being such a small percentage. So let me switch gears somewhat with a slightly different fact pattern than what we have in Ulander, and I'm curious what your reaction is for something like this. So take a game that is about a historical battle, the Battle of the Bulge. Now this game comes with 320 little tiny cardboard pieces. One of these pieces is for General George Patton. Now he's only one 320th of the playing pieces, but based on the Pro-Am golf case, based on the Ulander case, this looks to be a violation of Patton's possibly post-mortem right of publicity. How would you come out on a case that is about military history as opposed to sports history?
I think I would stay with the same, I guess it would be a conservative position, that if you have Patton and Omar Bradley and Dwight Eisenhower as pieces in that game, that they or their estates should have some right to use, to collect on that there has to be a consent. I wouldn't see it as being any different, although, as John pointed out, the dilution factor would be something you have to consider. But here you have the three top generals of that battle. I would say they're entitled to something.
And the something may be very little. The reality is there may be a technical violation that could be made out with that game, But what damage would you have, assuming you can get over potential defenses? But you would have very little in the sense that it's not focusing on any one character. That's another component.
Well, based on Eulander, you might be entitled to an injunction to stop the sales of the game. I feel like you might be shutting down the game industry, or at least the small players who aren't in a position maybe to negotiate licensing deals. Now, Electronic Arts is in a position to potentially negotiate, but for smaller publishers, and this potentially happened in the Eulander case, Stratomatic and the other sports games were at risk of being shut down by the licensing demands, although because Stratomatic was viewed so favorably in the industry, the Players Association was willing to work with them to make sure they could survive. To the extent a famous individual is able to demand a license in order to be portrayed in a game, are you worried that you may be inhibiting the growth of the gaming medium to do what newspapers and books and films and television shows can do, which is to comment in both positive and negative ways? If licenses are required, then one likely outcome is that games are going to have to be unfailingly positive in who they portray. Otherwise, no license for you.
Well, it may not even be a matter of positive, right? You just have to pay for it. I mean,
it depends. It depends.
To me,
right.
this is really disturbing, and I think that's why these sports games have implications beyond that. Unless we're just going to carve out games as the kind of black sheep of the expression industry, the idea that I couldn't make a game simulating the battle in the Pacific during World War II unless I could get the permission of the Douglas MacArthur estate. At least I couldn't have MacArthur in. I realize there is a separate question of when the right of publicity expires, but I don't know, if I want to make a game about the Gulf War, perhaps for purposes of teaching students what a terrible idea it was, the Second Gulf War, but I can't use General Petraeus or I can't use George Bush unless I get a license from them. It seems to me is really unfortunate. I mean, I guess I believe the games can be teaching tools.
Saddam Hussein does appear on the cover of one of the Gulf War board games that came out in the 90s, and despite being deceased, and I don't know if Iraq recognizes a postmortem right of publicity, but he has a potential claim under Indiana and Washington law.
Are his sons still alive?
Or his estate.
Somebody could file such a claim, and whether it would succeed or not, I think, was a real question. But you're right. Technically, somebody could make such a claim. I agree that when it's educational, and when the use is necessary. In other words, where it's tied into an explanation of an important battle, that's going to be a pretty tough case to bring on right of publicity grounds, where it's not highlighted and you're talking about people that played essential roles. And then it becomes in some ways less commercial, because while you sell books, you sell educational materials, it has this overriding educational purpose.
But isn't this game telling the story of professional golf in the United States in 1966?
The question is a matter of degree in some sense.
Yeah, to me, I like your example, Gordon, of a game that would somehow educate people to the mistakes of the Iraq War. To me, that's different from the sports games that we're talking about that are more strictly merchandise. As John points out, we have expression, we have merchandise. The pure merchandise games, to me, would be different. So we have to maybe redefine game. Maybe there has to be a subcategory that the courts are going to have to define somehow.
Well, the military-style games are not necessarily straight recreations of a historical event. They can also be used to consider a what-if scenario. And in some ways, I think the sports games are very analogous. We substitute for the battlefield the golf course. We substitute in for the generals, the golf pros, and we allow people to create a golf event that's tied to what happened in the real world, but you're going to alter it as a player. Now that depends on the degree of choices that the game designer gives you. A game designer could give you few choices and force you to sort of go through the steps of just recreating historical events. But that doesn't usually make for an interesting game. They need to give you some flexibility to try your own thing. But you do want that tie in these types of games and also in the historical game to the real world. You want to see the right people in the game. You want to see that the game has some tie to real statistics, and that players who do well in the real world should do better in the game.
I have seen that in the O'Bannon trial, no question about it. The EA executive vice president testified that for him to design and sell a game and make it a business success, he needs the names, the actual identities of the players. Using the avatars, they gave up on NCAA football and NCAA basketball. They need, the more specific the identity, the better they can sell, at least in that world of merchandise.
I have no doubt that that is a huge selling point for the games, and that for the games that aspire to be simulations as opposed to some sort of arcade baseball game. You might have a strictly arcade fun style baseball game that doesn't have any real players, but it also isn't meant to simulate the actual game in a meaningful way. But for those games that are trying to simulate the real world sports, they need those details. Let's bring things forward a bit. So we have the Pro-Am golf case, the Palmer case. We have the Eulander case involving baseball, and we also have the Rosemont case as part of this original trilogy involving Howard Hughes. So we get 3 cases that say if you're going to make a game, you're going to need a license. 2 of those games are based on sports statistics. The 3rd game incorporates a fair amount of Howard Hughes biographical information. None of the games are really in the category of the Rodney Dangerfield example or my hypothetical Orson Welles example, and yet the courts say you need a license. So for a very long time, we don't get any litigation that results in published decisions. Recently, of course, we get a lot of litigation. You've been sitting through some of it. Now, as we move up to the modern era, the courts start to become a little more sensitive to the potential First Amendment tension here. And the courts have to at this point, since the Supreme Court has said that video games are entitled to the same First Amendment protection as other forms of media. As courts have tried to wrestle with the First Amendment implications of the right of publicity in this context, they've considered what is the right test to apply. So what is the right test to apply? We don't really see the development of a test in these early cases, but we see that now. What's the correct approach in your view?
Well, the danger of, for example, the transformative use test is a matter of, it's hard to predict. It's a matter of degree and how greatly is something transformed. Well, I think it's transformed. How about you? And so it becomes a little bit difficult. But in looking at the 3 tests, like for example, the predominant use test, the Rogers test, the transformative use test, I think transformative use test gets to some of these nuances pretty well. And I think it's the test that is becoming the one that more and more courts we're going to see more and more adopt because it recognizes that there is expressive content here. And I think I could go into some of the other tests and their deficiencies, but I think especially in the last few years, it seems that there's more agreement that that's the test that and I could see why.
Now, the transformative use test comes to us from the California Supreme Court, and it comes to us from the case that involved this image of the Three Stooges that was being sold in print form. Now, the court said that this particular image violated the rights of publicity of the Three Stooges, or whoever currently retains those rights, because it's not transformative. It's a conventional, literal depiction of the Three Stooges. Now, you're right, the courts have been applying this test in the game context, but how do these games fail the test that is supposed to ask you're supposed to ask, are you just selling the image of the plaintiff? Is that the product, the image of the plaintiff? How are any of these NCAA games or the Madden games or any of the other modern games comparable to this? There's so much more than just the avatar. No one's buying it just to get a picture of any one player or even a group of players. You have to have a game that surrounds these images.
I think the structure of the game, the procedures of the game, and the rules of the game are very important, but it also remains very important to sales, initial sales of the game, that they have an identification of a real player that a consumer can see, can connect with, and can identify. And they use pictures on the covers of the games. You know, they take Tim Tebow and they put him on the cover of the game because they know that is going to sell the game. Now, they pay him for that, in contrast to the avatars that are inside the game. But the connection with a real individual is critical, at least to selling it. Then if it's going to last for a while, then the rules kick in, I think.
But that would be true for, say, a biopic. Take the film, since we've been using the example of Patton, take the film Patton. Clearly people would go to see that because they have an interest in World War II or General Patton himself. But General Patton is a selling point of that film, just as the real-world players are selling points of the video games. Now, based on what the courts have said, the games fail because you depict the players as they are in the real world. You depict these college athletes playing football in the way that they do in the real world. If you were to put them in some totally new environment, perhaps in outer space doing something other than playing football, maybe that would be transformative. And if you change their appearance, that would be potentially transformative also. But in a film like Patton or some other biopic, we strive for some degree of realism there. We depict Patton as he was in World War II, doing the things he did in World War II, and we want him to look something like he did in World War II. So why is Patton likely immune from a right of publicity challenge? And we'll find out the Ninth Circuit agrees with this in this Hurt Locker case that is still pending in the Ninth Circuit. But my expectation would be that the filmmaker prevails. That's the typical outcome, that filmmakers can take a real-world individual and depict them as they are in the world. But why does a filmmaker get to do that and not electronic arts?
Well, there's not really, with electronic arts, there's not really information being conveyed directly about that player in the sense of learning about that player, learning details. Like Patton, it's more akin to reading a book, a historical analysis, the biopic about him. And so I think it's a matter of purpose and degree and what is the goal. And one goal of the EA would be to just play and have fun versus watching Patton, where it's a fun in a sense. I like the movie, but you're learning something about him in a way in which there are few other means as effective as that film.
But see, I disagree at some basic level here. I mean, as someone who played the 1960s versions of these games religiously, they were enormously informational. I mean, the game invariably tells you biographical statistics of the player, even if it's just height and weight and where they were born. It gives you a way of evaluating their levels of performance. So just like baseball cards were a source of an enormous amount of information for kids who collected them and read the backs, right? So I agree with you, though, that the transformative test, I think, has the greatest potential. My real preference would be to just abolish the right of publicity, period. My second choice would be a broad First Amendment that basically made it irrelevant. But since neither of those two things are going to happen anytime soon, I do think the transformative test works if it's applied correctly. Just real quickly, I was thinking of a game, the game Candyland? If you had a Candyland with just pictures of Major League Baseball players around the board, well, that would be teaching you nothing about Major League Baseball. It wouldn't even be central to the game, so maybe that's a non-transformative use. But at least from the perspective of a former game player, it seems to me that anytime you play these games, you're creating a kind of new text. It's different than a written or film text because you interact with the text. You can't necessarily control where it goes. But it just seems to me playing a sports game of this type or the Madden type is clearly, to me, a transformative event. And that's why I think if that's understood, the transformative test is the best way to deal with this issue.
Well, the Rogers test from the Second Circuit would be my preference, and the question to ask would simply be, is the use of the plaintiff's identity relevant to the expressive work? So we have to be talking about an expressive work, not an advertisement, not a bag of flour. But if it is an expressive work, and we can put games in that category, the Supreme Court has put video games in that category, I think we could also put board games in that category, then we would simply ask that question. Now, the players wouldn't be relevant to Candyland. Orson Welles isn't relevant to the Othello example. Rodney Dangerfield isn't relevant to that Rodney Dangerfield game. I think the transformative use test could also be understood in the same way, but as applied, it's become a little more complicated. Although the California Supreme Court said that even news reporting can be transformative. You don't have to change anything, just give the facts. But the fact that you are providing more than just the name of a player, you're providing information, newsworthy information, that can be transformative too. Although the court said that, I think they've made it much more complicated in the game context. I suspect it's because they really resist the idea that games should be treated in the way that other forms of media are treated. But insofar as they've made it complicated, they've also made it somewhat less predictable.
Well, they're concerned, though, too. They're concerned about the implications if you go the route of allowing what EA did. What will happen next? The court, in some of these recent cases, the NCAA cases, have said that we're concerned about, if we accept the argument that it can be used like this with the avatar, we're concerned about potential abuses. So they also have that in mind, about not only is it an extension of like a newspaper or a magazine, traditional means, or even a T-shirt with political slogan on it, but they're concerned about the way technology, I think, can use that potential right if it was expanded that far and abuse it.
Well, I think technology does pose an interesting challenge in some contexts. So I'm not sure this one's relevant to games, but as the ability to replicate actors increases, we could imagine a movie studio saying, let's make a sequel to the movie, but let's not bring back the $20 million lead actor. Let's create him through CGI, and perhaps we'll have somebody imitate his voice, or maybe that can be computer generated also. When we reach that point, it starts to become analogous to the Zucchini case the Supreme Court decided back in the 1970s.
Well, they did that in The Sopranos. The mom, right, Tony Soprano's mother died, but they actually had her being portrayed somehow afterwards. Yeah. But at any rate, it's actually happening.
Right, it does happen now. I don't think
I think that was with consent.
Right, I don't think anybody's decided we'll make the sequel to Top Gun, and we'll have a younger CGI Tom Cruise, but the real world Tom Cruise won't be a part of this. We won't pay him anything. We'll simply have him recreate the role and make a sequel. I think that is a potential problem, and I am sympathetic to a claim in that context. I don't think the games, if that's the sort of abuse the courts are worried about, I don't think the games pose that problem. I don't think the recreation of the athletes in these games poses that problem. Now, to the extent actors are now involved in making video games, starring in video games, I could see the Zucchini-like problem arising. But that's an actor playing a role. It's George C. Scott playing Patton. These games are the actual athletes. This is Arnold Palmer in the game as Arnold Palmer, not Arnold Palmer playing a character. We're not going to put him out of business as a professional golfer, and we don't want to put any actors out of business either as actors. But insofar as we're putting the actual athletes as themselves in the game, I'm not sure that sort of scenario seems likely if electronic arts prevails. Is that the sort of abuse you're worried about?
I mean, I just read that was what the court said in the recent Ninth Circuit decision, that they're concerned about how potential, and they didn't elaborate on where that may go. It's kind of like I think in the realm of unintended consequences if we take this path. So and I think that, but they have the feeling that it could be what you said, or it could be something else that they're not seeing coming down the road, but that they were clearly uncomfortable for, among other reasons, extending the right to allow EA to do what it's doing.
I think comfort levels are important here. To the extent we've had licensing as the norm for decades, we're comfortable with it. So to the extent those early three cases set the standard, we've been doing this a long time. Courts that are conservative as far as this issue are going to think, let's not rock the boat too much. We've been licensing for a long time, let's keep doing that.
I'm not sure how closely this follows, but your comments made me think of this. My son used to be a big fan of Madden, and I would notice sometimes he would be watching an NFL game, and then the next time he'd come in the room, he had turned it off and was playing the same two teams against each other. And to some extent, I think that was a more appealing version of the Redskins-Viking game. I'd rather see the Redskins-Viking game with the same players where I'm actually calling the plays than I would just watch the actual game on television.
As a Vikings fan, I felt that way.
So I suppose this is another, I mean, in a sense then, are the games actually taking audience, have the potential of taking audience away from the actual events? And I suppose this would at least allow the NFL to reap something through license fees.
The National Football League is clearly worried about losing audience for various reasons. Right now, I've never heard them mention games as one of them. They're worried because TV is so good and high definition and all that. But that's a very interesting point. If that were the case, and the NFL were to come down on the Madden game, that would be a mighty battle. That would be a great thing for a journalist like me.
Well, we're out of time. I do want to thank my guests, Gordon Hylton, Lester Munson, and Jonathan Jennings for joining me today. Thank you very much.
Thank you.